Hello students, my name is Liz Attia and today's topic is the law and assisted reproductive technology, or ART. Okay, in terms of a working definition, what do we mean by surrogacy? Well, really, a surrogate is a woman who helps a couple to have a child by carrying to term an embryo conceived by the couple and transferred to her uterus, or by being inseminated with the man's sperm and either donating the embryo for transfer to the woman's uterus or carrying it to term. In terms of the relevant legislation here, the associated legislation is the Assisted Reproductive Technology Act of 2007. It is New South Wales legislation. There's been much debate in Australia as to whether there's a need to legislate to govern surrogacy or not. And you'll find that other states and territories in Australia have similar legislation to the New South Wales Act, being the ART Act. The objects of the Act, or the objectives of the Act, are in Section 3, and it states that the governance of surrogacy is specifically intended to prevent the commercialisation of human reproduction, to protect the interests of the following persons: a person born as a result of ART treatment, a person providing a gamete for use in ART treatment or for research in connection with ART treatment, and a woman who is undergoing ART treatment. So clearly the stakeholders. The Act governs storage of gametes, eggs used in ART treatment, and the procurement of gametes from donors. So in terms of what assisted reproductive technology is defined as, to be defined as ART treatment, it's defined to be treatment to procure pregnancy in a woman by means other than sexual intercourse. So really it covers a range of other procedures. It includes methods such as in vitro fertilisation and gamete intrafallopian transfer. Treatments are to be undertaken by registered medical practitioners, and gamete providers must also be registered. And counselling services must be provided to women seeking treatment. So you can actually see here that both the process and the procedure by which ART treatment is procured is actually legislated for and governed in the Act. So the Act provides for the creation of a register of donors, which can be accessed by adult offspring to gain information about a gamete donor. Specifically, Section 37 says that adult children must also gain information of other children, may also gain information of other children born from the donor's gametes, but only with the consent of those other children. So the donor can gain non-identifying information about their offspring. The donor can only obtain information about the offspring's identity when they are an adult and they consent. So here you can actually see that the legislation attempts to protect and balance the rights and interests of the different stakeholders in certain circumstances and situations. And clearly consent is pivotal to that release of information. So the Act allows the donor to place conditions on his or her donation, and this is actually really quite interesting. Under Section 17 of the Act, the gamete provider can give written notice and setting out the wishes in relation to how the gamete and consequent embryos should be used and where the gamete must be stored. So the gamete donor can clearly make it clear, can clearly indicate restrictions on race, colour, religion and sexual identity. And at this point, I'd ask you to actually consider what the implications might be there in terms of our Racial Discrimination Act and, in fact, our Sex Discrimination Act, and whether, in fact, in terms of the spirit of those other instruments of legislation, whether there is a contravention of what the intention is of the law to non-discriminate, to not be partial based on race or gender. and whether in fact giving and affording the gamete donor this implicit interest by restricting the use of the gamete contravenes the spirit of this other legislation. Now, if it's found to be the case, it's untested in law at the moment, but certainly you could actually make the argument that it's only a matter of time before this will actually be challenged. And in terms of, I guess, the way the legislation would work there would be clearly that under Section 109 of the Constitution, the state law, being the ART legislation, would be invalid to the extent of the inconsistency with the Racial Discrimination Act and the Sex Discrimination Act, as we introduced in earlier topics of this session. Okay, what about then in terms of conception after death? So there have been a number of cases where the spouse of a deceased man has sought to gain possession of the deceased sperm for the purpose of undergoing IVF, and these cases are usually split into two types: emergency applications to approve the removal of the sperm for storage, and to find out whether IVF storage can in fact be used. In terms of where the court, or what the court actually says with respect to this, it's detailed on page 99 of the textbook, and I'll refer you to those readings. Most recently in the case of Edwards, which was a 2011 case in the New South Wales Supreme Court. And in that particular case, in the Edwards case, the Supreme Court allowed for the removal of sperm for an immediate IVF procedure. But more traditionally, the court has been split as to whether they can make orders for removal. And in many cases, the courts have stated that they have no power over the corpse to order removal of sperm. But in other cases, the courts have said that they have an inherent jurisdiction to order the retrieval of sperm. And clearly the 2011 case sets some precedent there in terms of how the courts actually see this particular topic. You'll note earlier on in the slides I did mention the non-commercialisation of assisted reproductive technology as being one of the central tenets of the legislation, and that is to ensure we don't commodify the process and that we don't actually have a market in terms of selling and buying with the with the implicit risks then of the underprivileged being taken advantage of in some way. Thank you, students. That brings today's topic to an end.